Let's have another look at the contractual capacity of minors. Natural persons under the age of 18 years who are unmarried are called minors. The law distinguishes between the contractual capacity of minors aged under 7 years and minors aged between 7 and 18 years. A minor under the age of 7 has absolutely no capacity to enter into any contract and cannot accept any donations. A guardian may enter into certain contracts on their behalf regarding his or her maintenance and estate. If any contract entered into on behalf of the minor proves to be prejudicial to him or her at the time that it was entered into, he or she may, within 1 year after attaining majority, apply to the High Court to cancel the contract and obtain restitution for his or her entire performance. A minor aged between 7 years and 18 years is deemed by the law to possess an independent will but lacks maturity of judgment. Such a minor has limited contractual capacity and requires a guardian to assist them. It is possible, however, under certain circumstances, for minors aged between 7 years and 18 years to enter into valid contracts. One being with the assistance of the guardian. The minor will be bound by the contracts made on his or her behalf by his guardian or by contracts made by him or herself with the assistance of the guardian. The guardian does not have to know the specific terms of the agreement. He or she simply has to know the type of agreement being entered into. Then, on achieving majority, the minor may repudiate liability under a contract that was prejudicial and caused them loss. Minors who marry automatically acquire full contractual capacity. However, the decision by a minor to enter into a marriage must have the consent of a guardian. Any marriage entered into without the guardian's consent is void. A minor may be emancipated. This means that they will be regarded as a major. An emancipated minor may validly contract within the limits of emancipation. However, they may not contract outside these limits without the guardian's consent. The extent of emancipation is a question of fact to be decided by the court, depending on the circumstances of each case. If the guardian consents to complete freedom regarding the minor's lifestyle in the form of a general authority, then the minor will have full capacity in most circumstances. The case of Dharma versus Bera displays how this can be done. The minor lived with her parents, but paid for board and lodging. She sued her employer for outstanding wages. His defense was that she lacked the capacity to sue in her own name. The court held that she was tacitly emancipated and was allowed to sue her employer for outstanding wages without the assistance of her guardian. Furthermore, any contract entered into by a minor without the guardian's consent can be confirmed by the guardian or by the minor upon reaching majority. This is known as ratification. When considering the capacity to contract in the context of children, one must also look at the Children's Act. It provides that a child over the age of 12 may consent to their own medical treatments if they are of a sufficient maturity and have the mental capacity to understand the benefits, risks, social, and other implications of the treatments. The consent of the parent, guardian, or caregiver is necessary only when the child is of insufficient maturity or is unable to understand the benefits, risks, social, and other implications of the treatment. Furthermore, the Choice on Termination of Pregnancy Act states that a female minor, irrespective of age, does not require the consent of her parents for the termination of a pregnancy. There are also other provisions contained in the National Road Traffic Act and the Banks Act which should be considered, but we'll not get into that. Getting back to basics. Where the minor is assisted by the guardian in entering into a contract, the minor will be bound by the terms of the agreement. However, Where an assisted contract is prejudicial to the minor, they may apply to the court to have it set aside, and the other party must restore the minor to the position in which the minor was before the minor contracted. The action must be brought with the assistance of a guardian or within a reasonable time after the minor turns 18. Where the minor has entered into a contract on his or her own, without the guardian's consent, the contract is void. The minor cannot be held liable under the terms of the contract and is entitled to the return of any money or property given in terms of the contract. If the minor wishes to hold the other party to the contract, he or she may sue the other party with the assistance of a guardian or by him or herself upon the attainment of majority at the age of 18. On being sued, the other party must restore the minor to the position in which the minor was before they contracted. The minor must restore to the other person the extent of the minor's enrichments at the time of the court action or pay the other party a sum of money to the value of the benefit received. If a minor wants to escape such a contract and has lost the benefit, the law seems to have a bit of a problem. Should the minor get back his or her performance from the other party without returning the benefit received? On the other hand, why should an adult be allowed to deceive or take unfair advantage of an innocent minor? The law is clear that minors must be protected. Accordingly, the minor may reclaim his or her performance. If there is no benefit left, then that is to the disadvantage of the contracting party. Moral of the story, majors must always be careful about contracting with minors.